SJC-12953, Commonwealth v. Adrian v. Hinds.
Looks like we're waiting for Ms. Fraunhofer. You're on mute and we can't see you. There you are.
Thank you.
Okay. Good morning.
Good morning. Shall I begin, Your Honor?
Yes, please.
Thank you, Your Honors. Elaine Fraunhofer for Adrian Hinds. My goal is to have time to discuss at least the two issues this court requested amicus briefs on, and I'm going to begin with the trial judge's refusal to allow Mr. Hinds to exercise his final peremptory challenge. At the very beginning of trial, the judge informed the parties of how the stages of impanelment would proceed, including stating, we'll seat 24 or so people, in other words, not a specific number. And so the judge's general statement about the order of impanelment, his statement about the approximate number of potential jurors that would be seated, his related comment about the possibility of a second round of peremptory challenges, and especially the speed with which trial counsel requested the final peremptory when she realized the judge was not going to seat any more jurors, which was really almost immediately after she exercised her final or prior peremptory challenge, when really nothing of any significance had happened in the trial and before the jury was sworn. All of these factors taken together established that the trial judge erred when he denied Mr. Hinds his ability to exercise his final peremptory challenge. Fundamentally, the statements by the trial judge that about the
Counsel, could I interrupt you on that?
Yes.
Should we not at all focus on the juror that counsel was seeking to exercise the peremptory challenge to? And I mean that the reason why I'm asking you that is, weren't there multiple opportunities for counsel to strike this particular juror and it just didn't happen?
Multiple opportunities.
There were multiple opportunities to exercise a peremptory to this particular juror, wasn't it?
No, I don't think so. I think the judge did lay out this much clear that there was going to be an opportunity after Attorney Quadier. So he turned and said, actually, you asked the Commonwealth to exercise theirs and then asked the defendant to exercise theirs. There was only that one opportunity to exercise peremptories.
Okay, no, I mean that my reading of the record was that there were plenty of opportunities for this particular juror to have the attorney have an opportunity to exercise a peremptory to strike this particular juror. Am I wrong about that?
Yeah, I think you are. I don't understand where there would have been another opportunity. The judge, as he laid out in the beginning here, what the different opportunities, what the order of impanelment would be. He only said there was going to be an opportunity to exercise peremptories after you went through all getting all the jurors after Attorney Quadier, and then there could be another opportunity if there was going to be another round of jurors. So this was the only opportunity.
I'm confused then, because I like Justice George's, I thought that when the defendant struck 5 out of the 6 jurors, he had there was an opportunity to strike this juror, and that wasn't taken. And then a couple of minutes later, there was an attempt to backstrike the juror that was passed over.
Correct. No, that is exactly right.
So I guess my understanding was the same as Justice George's.
Well, I may be misunderstanding what Justice George was saying. There was this discrete time after 2 full days of impanelment had gone by, and the judge said to the Commonwealth to exercise their peremptories, and then and then there was a source challenge, and then the defense counsel was called up. She exercised the 5, and then at that point the Commonwealth exercised interjected a source challenge, and then the judge said okay, and then the clerk started to read the numbers as if this was going to be the jury, and that's when she realized. So it was literally, it would have been within seconds of her final peremptory challenge, but it was all within this couple of minutes. And again, nothing of significance was happening. There wasn't, the Commonwealth didn't object to this. It was just, I guess yes, there was an opportunity when she exercised the 5, but that's that's kind of the whole point. There was just that one opportunity, and it wasn't too far off. And it was not an explicit statement that it was so clear to the parties, to the litigants, that this was going to be their only opportunity.
Counsel, can you help me with the record a little bit? I thought what happened was that after the defense counsel exercised her 5 preemptories, then the clerk started reading who would actually serve on the jury. And then she realized that she had miscounted. And so said, oops, Your Honor,
Right.
I miscounted. Can I, and you're saying that that requires a reversal of the entire conviction?
Well, what requires reversal of the conviction is that she was, Mr. Hinds was not allowed to exercise his final peremptory challenge, which our courts are clear. When you have a valid peremptory challenge that you don't get the right to exercise without even establishing prejudice, because this is such a significant right, that requires reversal.
And that's
here,
even though it was really her mistake in miscounting the available jurors.
Yes, and I do think that her saying, "Oh, I'm sorry, that was my mistake," should be taken a little bit with a grain of salt. I mean, she clearly doesn't want to offend the judge, but the judge didn't actually give a clear statement of how she would have even known. What is a little bit confusing, because he didn't. This is again 2 days earlier when he gives sort of a general order of events. He says, we're going to see 24 or so people. So when she says, oh, my mistake, I'm sorry, I must have miscounted, I'm not sure she's really being, not just really trying to be a little bit diplomatic there.
Well, there was some concern that there might be a second panel, but I don't really think that there's much confusion. What the judge maybe should have done as a matter of discretion is one thing, but what happened here is, and appealing's difficult, and now that there's attorney voir dire, it's very protracted. It's quite honestly incredibly exhausting, and we've reached a point at the trial where the defendant has passed over this particular juror and made the decision about the peremptories, and trial attorneys understand, well, okay, now we're at the end of the impanelment, that the jurors have been passed over, everyone's indifferent, let's start. And you laid out pretty carefully in your brief the timing. I think you had a 5-minute delay in between the last peremptory and the judge's denial of additional peremptory. What might have been the perfect thing to have done is one thing, but I just don't see where there was an error here, and as was referenced by Justice Midland, I mean, we're going to reverse a conviction because the lawyer passed over this juror. Seems like you had an indifferent jury, and then she wants to exercise it later, and the judge doesn't let her, and now we're going to reverse the conviction.
Well, I think the important issue is, you say 5 minutes later, but I want to point out that almost all that time was taken out because the Commonwealth interjected a source challenge. So really, she said it, the source challenge, and within seconds of her realizing that there's going to be this is going to be the jury and there's not a second panel, she interjects. So I do think it was an abuse of discretion not to give no leeway when what Rule 6 says is that a judge can require a specific time. But I think given how significant this right is, that requirement should be explicit, and it shouldn't. And then there's that, and then it wasn't a specific, explicit requirement. And then the other end, the time frame for when she exercised it, when she realized, oh, this is my opportunity to do it. I'm going to exercise it. It was so close to when she had exercised her last peremptory. Those two things taken together, I think trial judges should, if they're going to take away this incredibly significant right that parties have, they should be required to have it be a pretty explicit requirement. It's not that much to ask to say, at the beginning of trial, this is going to be your only opportunity, or when they're calling them, this is your opportunity. And then she said it, and there wasn't a do you want to exercise your last one? Nothing. They did sorry, so I'll just say that, say that.
You-
So you are
have
focusing on reverse
complicated-
conviction,
you have
but
complicated expert testimony issues to address.
let's turn to those. Thank you, Your Honors. So the first one I'm going to address is the issue of the trial judge's decision to preclude Mr. Hinds from calling his experts who were going to testify about the symbolic significance of the victim's, Nathaniel Cherniak's, tattoo. Hinds testified he had been the victim of a series of seemingly racist acts by unknown persons.
Counsel, before you get there, could you just address this? It's seeming that there was an issue about whether or not this should be subject at all to Daubert-Lanigan. Can you get to that issue before you get to the substance of it? Do you think that this is the kind of thing that needs to be subjected to a Daubert-Lanigan hearing?
You know, I was the one who raised that because I couldn't find any cases where it said Daubert-Lanigan applied to this, you know, person testifying about the significance of the meaning of a tattoo. Neither has the Commonwealth been able to find it. But I do actually agree with the Commonwealth that Daubert-Lanigan should apply in order to ensure the evidence is reliable. It does require someone with some unique level of, you know, knowledge or training and an assessment of how sound the reasoning is. But I do think it's important to note that Daubert and Lanigan were both cases that were created to expand, or, you know, developed, I guess, to expand the body of relevant facts that could be introduced into evidence to allow, you know, novel but reliable evidence to reach the jury. And so I think that's an important point to make. I'm going to go back to probably some of that again, but I'll just say that here in this case, the significance of the testimony to the case is important to recognize. So Hinds had this testimony that, you know, he was the victim. Everything he did was in self-defense. He saw this man, Cherniak, slash his tire. He goes out to verbally confront Cherniak. And
can I stop you there for 1 second? Because the victim and the defendant are at one point friends. They're even talking about starting a business together. So is all of this just kind of nonsense? Because they're friends. This isn't sort of I mean, it may turn racist, but it doesn't. They start out as buddies. They have a falling out. So why should we be looking at whether he's got, you know, a racist tattoo on? Because it's going to be inflammatory and it may have nothing to do with what's going on here. It probably doesn't.
well, that's one way of looking at it. But another way of looking at it from Mr. Hinds' perspective is that it does. And it's, you know, what you're talking about is the weight, and that's something for the jury to decide.
I understood the judge didn't do a prejudicial versus relevancy analysis of this. He rather approached it through a Daubert.
Right. And the problem was that he didn't do a prejudicial versus probative analysis, but he inserted a prejudicial prong into Daubert-Lanigan that doesn't apply. So that's just, you know, one of the problems with his Daubert-Lanigan analysis. The other is that he basically what he said was sorry, lost my place. I don't agree with what your conclusion is, that this tattoo is the same as the tattoos of the symbols that you have shown me in these hearings, because the font doesn't match the font on Mr. Cherniak's arm. And of course, this is despite the fact that both experts testified that there was not one unique way that the number was written or tattooed, despite the fact that the evidence submitted, that photographs backed that testimony up, and despite the fact that there was no evidence to contradict that. So it didn't even make sense, the judge's.
Ms. Fraunhofer, and I hesitate to weigh in when there are two evidence professors on the panel besides me, and I'm not an evidence professor, but they're both scholars, right? They're both scholars of racist movements, or right?
I guess Dr. Bjork James more, but yes, I would say there were scholars.
They're doing sort of traditional scholarship. They're looking at documents. They're, they're going through databases. Just seems like this is kind of a weird Daubert-Lanigan case, but I will defer to the two experts. But can you address, which I guess makes your point, this is really a weight of the evidence issue. That's a traditional scholar doing a traditional kind of analysis of documents and symbols.
Right.
We're not talking about, so this should have been a weight issue. That's essentially, is that your argument?
Essentially, yes, Your Honor. Yes. I mean, I just say that in a standard Daubert-Lanigan analysis, I mean, I think the reason why this never, you can't find any cases is that this evidence just comes in. It's not rocket science, like there are scholars, they do the research, they, read the FBI reports, they look at the Southern Poverty Law report, they read whatever, website, they look at the pictures and they say, I'm a sociologist or I'm a cultural anthropologist. Yeah, that's what this tattoo means. I can tell you that. That's not, it typically would not be something that would present such an enormous problem. So the second flaw that's important to note about not letting it in is that he was so focused on the gang affiliation that even though it was absolutely clear, the defense counsel could not have made clear that they were not going to be alleging he's a gang member, or not, and even that he's a white supremacist. But the fact that he has a tattoo of a 211 that is affiliated with a group out of New York City that's a white supremacist group where Mr. Cherniak came from, that's relevant evidence. I think.
Counsel, can I ask you a question about that? It seems like at least expert De La Cruz found that out by Googling.
Mhm.
Is that a reliable method? I was a little confused by why that expert was not kicked out on reliability. That is that there was some recollection of the 211, and so she goes on Google, or he goes on Google, and says, "Oh yeah, that's right. That's that crew out of Colorado, and maybe there's some experience with that crew." But then the extension to the Boot Boys, I guess, in New York City, that all comes from Google searching. Is that?
No, he didn't say that all came from Google searching. What he said was I didn't mean to be so harsh. What he said was, I did Google it. And I want to say that Google is a powerful search engine. If I'm trying to remember the name of a case and I just remember like a phrase, I could just Google it. And then I go into Westlaw and do my Westlaw research. It's just the fact that somebody might Google something to, get to the Southern Poverty Law report, or get to the FBI report, or get to, the myriad sources where these people, share information. I don't think that negates the validity of your research. And I don't think he said that. But even if he said that, and you could kick out Dr. De La Cruz because he said the word Google, or used Google, which I don't think is an appropriate way to kick him out, I think that that's certainly not what Dr. Bjork James testified to. So I think that at least that should have come in. And I think here the point is that this was not a slam dunk case for the government. Mr. Hinds was acquitted of 4 of the 6 charges. The independent eyewitnesses' accounts were not consistent with what the victims alleged. Here, he was the only witness in his defense. The government put on 17 witnesses. This depriving him of this information, definitely could have tipped the balance in this case. We don't have to prove that he would have won the case at this point. We don't know what the jury is going to do with this.
Chief, may I ask another area on the expert testimony briefly? Yep. Thank you. I think we need to take a big step back, because you don't start with expert testimony, you start with relevance. And the relevance from the defendant's perspective points out why the Commonwealth's brief misses the point, because they're focused on whether or not this symbol allows testimony as to whether or not the victim is a gang member. And that's just not why you're offering the evidence. You're offering the evidence on the issue of self-defense and who is the first aggressor and the reasonableness of the response, correct?
Correct.
So if that's the case, was there testimony that your client had any knowledge of the tattoo and what it meant?
No, but I want to say this about that.
But that's a big problem, isn't it?
No, it's not. I don't think so. And I'll tell you why. I think this is akin to the situation of where the courts now allow evidence of, in a self-defense case like this, evidence of the victim's prior act of violence.
I have looked everywhere. I have looked everywhere for an adjutant case. Adjutant is not cited in your brief. It's not cited in your reply brief. I assume it wasn't presented to the judge. What you're saying is you want to put on evidence of the alleged victim's character for propensity purposes to make it more likely that he was the first aggressor. That's Commonwealth versus Adjutant. Not only is it not mentioned in your brief or your reply brief, was that theory, by the way, not a bad theory, was that theory in any way presented to the judge? And was there any argument made that there is no prior bad act of violence? It's a symbol. Was there any suggestion that adjutant would reach that far, which we've never done?
I think that Your Honor, that's just my failing that I didn't think about adjutant until after I filed my reply brief. So, but
I'm not concerned about that. I'm not concerned about that. I'm concerned that the trial judge, the defense attorney, never presented this to Judge Riccione. This is complicated. I mean, we don't have time to get into all the complexities that have been touched upon on the expert testimony, but this is incredibly complicated on relevance and on the alleged victim's character for propensity. That theory that you didn't mention in your brief that you're mentioning now, that's very interesting, was never presented to the trial judge to analyze.
Well, I don't know that it was never presented. I think that was, I think that's implicit in why you would want the jury to know that the victim has a 211 tattoo. There's not really too many other ways to read that you want to, it obviously is, I mean, he said, I understand what you're trying to say. I understand you're trying to say that he's got this 211 tattoo, but that's pretty prejudicial. And why else would you want it? That, and she never said that Hinds knew that, that he had a 211 tattoo or what it meant. Most people don't. So I don't think that this is such a out of left field thing that the judge wouldn't have understood that's why it was being presented.
You understand, I hear you. You understand though, and would agree that this is not an issue that's preserved, the argument that you're making now that it's a substantial risk of miscarriage of justice analysis that we have to do.
I guess I would say that it was preserved, that we wanted to present this evidence, that it was crucial to the defense, that it tied into the defense as to why the whole self-defense argument corroborated Hinds's accounts. And so I don't think it wasn't preserved. No.
Counsel, I just want to make sure I understand this particular part, not the notice part. But are you saying that there is no dispute between you and the Commonwealth that the trial judge made a finding that, at least with respect to the first expert, that they were qualified as an expert under Daubert-Lanigan, and it's the other part, that the disagreement with the conclusion that you say was the abuse of discretion?
Yeah, I'm sorry, might not have understood your question.
To Justice Wendland's point, are you saying that the judge made a determination that the former gang member, I think, I can't remember his last name, is it De La Cruz?
Yes.
Okay, that Mr. De La Cruz met the test of Daubert-Lanigan to be of aid to the jury?
Yes.
So you're conceding that, or at least there's no dispute about that?
I mean, there's no dispute. He said he's an expert. I agree he's an expert. He just doesn't agree with, he said their methodology, but in fact, he's saying, I don't agree with your conclusion. Okay. And he does the same thing with Dr. Bjork James. All
right, thank you. That's what I just wanted to make sure that we were on the same page with that.
And I just want to say that the error on this part of the judge, on this part of excluding that important evidence to the defendant's case, should be viewed in combination with the other evidentiary errors that the judge made, where he kept the Dr. Zeisel out without doing the proper analysis of that's a psychologist, and the preclusion of other evidence claiming that they were not an exception to the hearsay when they clearly were an exception to the hearsay. and I guess I want to just one second about prejudice versus probative. In this case, the government was allowed to present evidence that of 9-month-old text messages that Mr. Hinds sent to Cherniak. These were pretty prejudicial, but and pretty remote in terms of probative value. So that it just seemed that the judge was, had this heightened concern about the prejudice of this testimony and inserted it into his Daubert-Lanigan analysis improperly. And yet all sorts of prejudicial information was going in against the defendant. It really deprived him of his defense. And I want to say, just in a broader space that defendants are going to always be at a significant disadvantage when getting this information in. In all of the cases we can find, it's only the prosecution that gets to put this evidence on. So to create this new and higher standard just for defendants is kind of unfair. And I think that it's not completely illegitimate, but I certainly think there should be some recognition that defendants need to put their defense on. And in all the other cases, it was pretty much police officers who defendants don't get to call. And so
Can I just ask you what you mean by new and higher standard for defendants when they want to
that it has basic, I mean, I say new and higher standard, but really what I'm saying is not the erroneous standard that the judge used, which was that I need to agree with your conclusion, which is really should be for the jury. And you need to show me that you can prove he was a gang member, even though you're not saying he's a gang member. And it needs to not be so prejudicial, even though that's not part of the
But obviously that wouldn't be the correct way to do it for either side, anybody.
Correct.
Okay, very good. Thank you. Okay, Mr. Cole-Flores.
Morning, and may it please the court, Joseph Cole-Flores for the Commonwealth. I'd like to begin by addressing the expert's appeal. Daubert-Lanigan has long applied since Kumo, and most recently in November in Ernest E., in which this court held that Daubert-Lanigan applies both to hard and soft sciences. Therefore, when Judge Richard Doney looked at these two experts after 2 days of evidentiary hearings, he was well within his discretion to find that there was no reliable methodology underpinning either of the experts' opinion that Mr. Cherniak had a...
Counsel, let me jump in on that, because that's the reason why I was asking your sister about the issue of whether or not they met the test for being qualified as an expert. So if that's the case, why are we looking at the reliability? Because it would seem to be baked in to the fact that the judge made a determination that they are experts. And the point that your sister was making was we're past that with the trial judge, that he made the determination that they met the test of 702. But it's the conclusion that they had the problem with. Well, if the reliability was faulty, doesn't that go into the threshold question of whether or not you have anything to offer?
Yes, Your Honor. And when we're looking at the common law guidelines, there's certain factors that an expert has to meet before that person is qualified to give an opinion at trial. Part of that, yes, is being a well-educated expert within their field, but also part of that is looking at the underlying theory and data and knowledge that is used, and then how it is applied to the matter at hand. Now, Judge Richard Doney gave his findings after a full day, and he gave it orally at the end of the day. So I believe that while he may have said some things that may cross the line to of the ultimate opinion not agreeing with it, when we're looking at the totality of his findings, he majorly disagrees with the underpinnings of that conclusion. So he really is finding no reliability to how they researched and how they applied that research to these two experts. So I would disagree with counsel that Judge Richard Doney or the amicus question, that he might be conflating the issue of reliability of theory and reliability of the ultimate conclusion. When we're looking at, let's start with Dr. De La Cruz. He talked about 8 factors, and he referenced this both in his thesis as well, I believe, in DOJ gang criteria. These factors include an interview and general history of the defendant, the educational background, prior criminal history, criminogenic family history, substance abuse, association with known gang members, employment, and lastly, tattoos. Now, it was a long Daubert hearing for Mr. De La Cruz. And ultimately, and I just want to read this quote out to you. I haven't had the opportunity to do any of the things that I usually do in a court case, right? So I have to just base it on the tattoo. That answer was given on redirect after question by the defense counsel.
To determine what?
To
To determine what?
the question or ultimate, the answer is to determine whether or not he's a white supremacist.
No, to see whether he's a gang member, right?
Yes, in my mind,
Two
those
different things, two totally different things. Yeah, this is not what the defendant's theory is. You're arguing something that's not the defendant's theory. The defendant's theory, you just pointed out the criteria for whether or not somebody is a gang member or not. And tattoos is one ingredient that an expert might indicate goes into the analysis as to whether somebody is a member of a gang. That's not their theory of admissibility, nor is it their reason for offering expert testimony. They point this out in the reply brief. So that's not, maybe what you're going to say is, oh, this is a new theory. They didn't tell this to the judge. But what they are saying is that the tattoo is evidence that he is a white supremacist, and that this is a racial incident, and it makes it more likely than without the evidence that he is the first aggressor under Commonwealth versus Adrian. So when you talk about whether tattoos are only 1 out of 8 factors, or you talk about whether or not this tattoo would show that they're a gang member, that's not answering the theory of admissibility on which the gang member, in which the evidence was being offered according to the defendant's brief. Now, you can dispute it and say, no, that's not what was litigated at trial, that's new. And if that's the case, I'm really interested in hearing it. But the issue is not whether or not the expert's testimony satisfied gatekeeper reliability that the victim was a gang member. That's just not their theory on appeal.
And I tend to agree, Your Honor. When we're looking at the Daubert Landing gatekeeper, these factors are going to whether or not he is a gang member. And I think that is a major problem with this expert. Whether or not there is a relevancy to a self-defense claim where a defendant leaves his apartment to engage in somebody, or whether or not there's a defense of property, or if there's adjutant evidence, it is another question. When we're looking at this is Dr. De La Cruz is from California, and he spends at length, including his thesis discussion, discussing these 8 factors. And so the totality of that is that he's looking whether or not it's a gang member. Now, admittedly, he only looks at one. And there's been a lot of discussion of this tattoo and the 211 numerals on it. But I would argue that, and I think this is what Judge Richard Doney was trying to get at, it's a 211 tattoo. And the McDill brief, I believe, goes after the fact that he's mixing up the conclusion. But I would argue that to let this opinion in on this kind of basis, where we're discussing gang affiliations, where at trial, the defendant states that the victim admitted he was a member of the gang, but trial counsel says, we're not arguing he's a gang member. I'm not certain that a jury can tease out the difference between a defendant saying he's a gang member and the admission for not being a gang member being the basis for the expert opinion on a tattoo for being a white supremacist.
Is the defendant's theory on appeal not what happened at trial? I have no idea. I haven't read the whole trial transcript. But what they're saying is, let me say it more straightforward. They're saying that they've got expert testimony that 211 means white supremacist, and that the fact in these circumstances of this relationship, white supremacist makes it more likely than without the evidence that he's the first aggressor, And that if you look at the foundation for, not that they're a gang member, but that 211 is white supremacist, that the judge is deciding whether he thinks that so, as opposed to whether or not there's enough evidence to satisfy gatekeeper reliability for that opinion. And that's what they're telling us now on appeal. If that's not what happened at trial, and that theory of relevance to apply the expert testimony to is not what happened at trial, I'm interested in knowing that. The defense says it was.
In my review of the transcripts, I do not recall any adjutant evidence being discussed or offered up for admission anywhere in the trial or pretrial stages.
Isn't that the whole point of, wasn't that the whole point of the case? I mean,
Well,
isn't that the defense?
That was the point of the defense, right? Was that Hinds was concerned and had been the subject of what he thought was racially motivated action beforehand, and therefore that's why he did whatever he was convicted of doing.
Right.
That was in reaction to that and that attitude and that belief.
The word adjutant was never argued, and I think it is inherently.
Yeah, no, but you don't, let me just ask you this. How is this not about the weight of the evidence versus the admissibility of the evidence? And that's really the only question I think is outstanding. I understand that you're saying, oh, you know, the judge was correct, but everything that the judge said about the evidence goes to the weight and why a jury may or may not believe what the expert says, not whether the jury should hear it at all.
Your Honor, I respectfully disagree. If it were admitted, these arguments would be made for the weight, but a judge has to act as gatekeeper to ensure that an opinion is relatively reliable before it gets to the jury.
Counsel, that's why I keep getting confused, and I hate to sound like I don't understand what you're saying. But if that were the case, wouldn't that militate the conclusion that Mr. De La Cruz would not be qualified as an expert? Go back to Justice Wendland's point. The whole point about being an expert is you've got something that the average layperson in the jury doesn't have. And if the average layperson in the jury can go to a website, look at a numeral that's a tattoo that's ostensibly affiliated with a white supremacist group, or go to the Southern Poverty Law Center's website and do that own kind of analysis and look at what's on the victim complainant versus what are some of the other images that exist for members that are affiliated with this white supremacist group. What is special about doing that the average person can't do? And so if Mr. De La Cruz did that and it satisfied the trial judge that that was reliable methodology to conclude one way or the other, but then he says, I don't conclude that. Doesn't that directly go to the issue of weight? Because he's already made the determination that he can testify as an expert.
I don't necessarily think that he's made the ultimate conclusion that he can testify. When we're looking at the common law factors to look at the admission, the first one is that his expert testimony will assist. Let's just assume that if he were to be, it would assist eventually. But he has to be qualified as an expert, and the facts have to be reasonably reliable, and the application has to be reasonably reliable. All of these factors have to be found.
Sure.
Dr. De La Cruz, yes.
So are you, that's what I'm asking. Are you contesting that the trial judge concluded that Mr. De La Cruz met the test of being an expert?
Well, I don't think the answer to that question is conclusive. He found that he was knowledgeable in the area, yes. But it's just because he can Google it, he needs to have a further application that qualifies his research as reliable. So I believe Sister Counsel mentioned that she can Google and then goes to Westlaw. Mr. De La Cruz can Google the information, and then he has to backstop it with something more professional. Here, he admitted that he does interviews of clients and does a background history before he comes to any conclusions that somebody is a gang member or whatever conclusion that he is seeking to verify or disprove.
Okay, listen,
But-
I think we've covered this pretty well, and I think we get your point. I want to move you to the other issue about the peremptory challenges, just because we're running out of time. And I guess my question would be, I know a lot of times judges will say, here's how peremptory challenges are going to work. You have to exercise your peremptory challenge in such and such a manner. And it sounds like that did not happen here. Is that a fair statement?
I would point the court to the trial transcript on, just lost my outline here, on page 1, volume 1, early on in the transcript, I lost my page, so I believe it was page 8. He says that once they have a full panel, they would do the panel voir dire, they would do the for cause, and then they would do the peremptories. So at a baseline, before any of the jury impanelment begun, counsel was aware that after the for cause challenges was the time to exercise any peremptory challenges. So under Superior Court Rule 6, that was the time that the trial judge designated for peremptory challenges. Now, I think there is a little bit of confusion as to the ultimate timing of the last peremptory. The defendant exercised 5 peremptories. After looking at it, the judge and the clerk both questioned whether or not the attempted use of a for cause challenge for one juror and then the non-use of a peremptory for that juror was by design. Counsel said, yes, that was by design, indicating that she was aware that she had that one peremptory left. So when it moved on, that was the conclusion. That was the time for Superior Court Rule 6 to exercise peremptories.
You're saying, I'm sorry, I'm not understanding you. So she tried to exercise for cause and was not successful, or she was successful?
She exercised a number of for cause challenges, and there was some challenges to a swords challenge. She exercised for cause challenges, and after that, she attempted to use the peremptories. One of them was for a different juror than the juror that's being questioned right now. I believe it was 86
Right, so
or 87.
Lieutenant Juror 86 was the for cause, and then the clerk said, hey, when you exercise the peremptories, you forgot juror 86.
That's correct.
He said, no, I didn't forget. I did that on purpose.
And then the juror that
and then
were
later on, she wanted to strike juror 59.
that is correct, Your Honor.
Okay.
So that is the timing of it. She attempts to use that peremptory after everything in the middle of when the clerk is saying, juror number this, go to this seat. So they're in the process of seating the jurors. She says, Your Honor, may I be heard? And he says, please wait. And they finish attempting to seat. And so it's literally at that last moment when the defendant is attempting to use that last peremptory. Judges afforded wide discretion in jury impanelment, and where the judge offered and reminded, and the defendant had multiple opportunities to use the peremptory, there can't be an abuse of discretion.
Does
So,
anybody have any- go ahead.
Chief, go ahead, please.
Yes, no, please.
So I'm on the transcript page, for volume 1, page 8 and page 9. And the judge is explaining everything, and he says that, we'll go through the group questioning, the individual questioning, attorney conducted voir dire, then I'll ask cause, and then I'll ask you to use your peremptory challenges, and hopefully we'll get a jury impaneled with one panel. And then he talks about what might happen if he goes to a second panel. And your position is that he's clearly saying, after everyone's found indifferent, I've dealt with the cause, then you exercise your peremptories, and then we have a jury. And you're saying that that was enough to lay out the plan.
Yes, Your Honor. It's
And
very
the
clear.
ambiguity about what might happen, and I'm not saying this is right, I'm just want to understand your position. The ambiguity about what might happen with peremptories was if you got to a second panel. Is that your view?
Yes, Your Honor. And I believe the trial judge, and I apologize, I wrote this citation to the transcript down, but in the middle of the second day, towards the second half, he states that, as you may have noticed, we've gone past the initial 24 that we had discussed. We've impaneled 28. I believe that this will be sufficient to impanel a jury. So from day one and from at least the middle of day two, council was aware that this was more than likely going to be the one panel necessary to impanel for jury.
Any other questions?
No, thank you, Chief.
Thanks so much, counsel.
Thank you, Your Honors.
Your Honors.
Thank you.